So. Nur, dass ich hier alleine. Ist langweilig, aber naja. Ja, weiß nicht. Fangen wir an. So, we can start. I wish you a very nice morning with a lot of knowledge and know-how, because today we're speaking mostly about know-how protection. My name is Thomas Hoeren, and I'm organizer of this course, Law of the Digital Economy. I hope everything was fine last time. If you have any question left, you can send me an email or write in the chat. It would be very nice, of course, if you can open your camera and close your microphone. Very nice, Ms. Fauser, very helpful. I send welcome to the audience as well. We have few speakers, native speakers, which are apparently shocked due to my very bad English. I hope it will improve during lecture. So if you want to criticize me as a German speaker, don't do it. Last time we have spoken about the general principles of information law. And we have discovered that there is, in my theory, a clear swing principle: information wants to be free. This sentence is as stupid as possible, because why do I know that information wants to be free? Why doesn't it want to be paid? We call that in the philosophy of Immanuel Kant an axiom. This is not a principle to be proven, but a principle, kind of axiomatic religious belief. But it's a very good religious belief, because everything constructed in the course can be governed, can be starting with the principle information wants to be free. We have discovered the principle was mentioned in a very important document, or Declaration of Independence of the Internet, written by John Perry Barlow, a strange hacker in the 80s. But that was a starting point for a huge discussion on information law. When you say information wants to be free, every kind of intellectual property is an exception. It has to be interpreted narrowly in order not to undermine the principle of freedom of information. And limitations, for instance, in copyright law, is only giving the public freedom of information back. So that was the discussion last week. And this week, we are starting with one of the rare exceptions to the freedom of information, because that is trade secret protection. I will show you my slides. By the way, this time, even YouTube does work. I'm very happy. So, trade secret. Why do we talk about trade secret? Where does that apply in practice? If you take the whole world of economy, of world economy, the most important trade secret is, of course, this recipe of Coca-Cola. It's most powerful, most valuable in economy. It's a very secret composition of mixture of herbs and ingredients only Coca-Cola knows, most protected by trade secret. In Germany, where I'm coming from, we have also an example. You won't believe it if you are from Germany. The most important secret is Underberg. It's a very strange alcoholic drink, which you shouldn't use, and it is terrible to drink Underberg, but it's protected by trade secret because it was kept very secretly by the owners. So we have two situations of where trade secrets are endangered. The one is a violation of secrets by the employees, because they are stealing the recipe of Coca-Cola and building up their own company. That's very, very nasty. And the other situation is in a business-to-business relationship, if you are a small company and you have ideas, you say, another competitor is stealing my ideas, stealing my trade secret. So it's very important to be protected in these two situations. Is that an exception to the principle of freedom of information? Yes and no, because trade secret is not wide range intellectual property right. It's a principle of unfair competition. It's unfair to do it. The Commission holds the view, the European Commission holds the view that it is not an intellectual property right, but a small intellectual property right. They are not sure whether we can apply principles of copyright law or of trademark law to that new regime. So to start with the problem, the starting point always is the United States, because they were the first country in the world who invented, of course, trade secret protection. In the Uniform Trade Secret Act, UTSA, is not an act of the whole of the United States, but it was enacted by more than 47 states, US states, because the federal level doesn't have the power to say, I force all the states to do it. But they have made a kind of recommendation to have this Uniform Trade Secret Act, which needs to be implemented by all the states separately. So we have more than 47, I think 51 US states, and each state has a Trade Secret Act now. In the Uniform Trade Secret Act, there was a note explaining how it works, because forbidden in this UCST is to use information with improper means. What does improper means mean? It's theft. That's a typical example of an employee stealing all the data and ideas of a company, bribery, misrepresentation, breach of a contractual duty to maintain secrecy, or this topic espionage, a Russian hacker trying to use electronic means to get to the trade secret. The other way, which is forbidden, is to use information of a third party by misappropriation. That means, in the definition of Section 1, acquisition of a trade secret by a person, and now it's getting important, who knows or has reason to know. That means who willfully or negligently uses a trade secret which was discovered by a person by improper means. You remember improper means just discussed. That means an employee is stealing information and a third person says, wow, this employee is a great guy. I will employ him in my company, being the competitor. Let me use one example for that. I was an expert witness in a very important US case. This was Uber against Google. So, because in Uber, a guy was working for the company and he had knowledge of all the customers of Uber. And he has left Uber and went to Google. Google doesn't make any mistake. They said, please, it remains, everything remains secret. We don't want to know anything. But they asked him to give away all his email contacts of the company. So they get indirect knowledge of every customer speaking to Uber, and they were sued for 30 million US dollar, and they won. So that is misappropriation used by a third person to get the secrets of a competitor. The same applies for a disclosure of trade secret of another without express or implied consent. So if you are a third person, you should be very aware what you are doing. If you are using a former employee of a competitor within your company. Trade secrets, there's a definition in section 1 as well. C is a very broad definition, information including a formula, pattern, compilation, program that involves everything which derives from independent economic value and is a subject of efforts that are reasonable to maintain its secrecy. In this definition, you will find two elements which you will find in Europe as well. One is independent economic value. That's very important. You have to show that an idea has an independent economic value. And second, efforts that are reasonable to maintain its secret. You need adequate measures to protect your secret. So the United States were already very successful in determining remedies. So you have injunctive reliefs, you have damages, you have attorneys' fees which need to be paid back. So a wide range. But if you compare the United States with the European standard, which I will explain in very much detail, you will understand, compared to the European standard, the protection in the USA is very limited. A trade secret holder is only protected from unauthorized disclosure, which is a misappropriation or made by improper means. However, this standard was applied in a very important international treaty called TRIPS. TRIPS is trade-related aspects of intellectual property rights. That's an international public law treaty made by the WTO. So they use the US definition in the treaty. So now I will change because I want to talk a lot about the directive. I hope you all here as well have printed out that material. You are international students, huh? So you haven't got any email. You have one copy left. You have. Yeah, I know. You can find them on the internet, but I have one copy left. So let us first have a first glimpse to that directive. So if you want to see it on your laptop, you simply type in European Directive on Trade Secret. Then you find the text as well. So to get a first impression about directives, you have got a link to a video for especially for non-EU students, which explains how the European institution drafts legal text. They have three types of legal text. The one is a regulation, the second is a directive, and the third one is a recommendation. So a regulation, we were talking about regulation in summer term. There are a lot of regulation on data ownership. A regulation is fully binding for every European citizen if the European Commission and the Parliament decides upon making a regulation. Every citizen in Europe has to obey and implement this regulation. A directive, of course, is not binding for every citizen, but for the states. So the European states have to implement that directive in their national legislation, and if they implement, is of course binding for the citizens. So there's a step in between. A recommendation, for instance, is not binding at all. So between recommendation and regulation, you have this directive. So the starting point is, of course, this text is published in the official journal. That's the most important part for getting into force, is publish it in the official journal. Then you see there are some remarks on the beginning, having regard to the treaty, having regard to the proposal. That is part of French system. The French always explain in formal sentences what has been made before. So the steps to draft that regulation, that directive. You see, in this part, it's mentioned having regard to the treaty, and in particular, Article 140, because the Commission and the Parliament needs to find norm, a section in the European Treaty saying you can make a regulation or a directive. Only if they find a competence norm, they can draft it. In the past, we had a tobacco directive planned by the Commission for prohibiting advertisement for tobacco. And the European Court of Justice said, no, it's very important to draft it, but you have no competence to do it. And they stopped the whole directive. So they need to find a norm allowing them to draft these directives. Then there's a second section starting with whereas. That is the so-called preamble and the recitals. There you find what has been the reason for drafting a directive, is sometimes this preamble can be pages long. So the European Court of Justice only uses this section for in order to see why the Commission and the Parliament has drafted this directive. So it's used for interpreting the directive as such. Then there's Article 1. There you find the subject matter, what is this directive about? And then you have a former, very important Article 2 with definitions. No? And then you have the text as such. So why has a directive on trade secret been made in Europe? So there were two studies made in 2011, 2013, and the studies noticed that there's a divergence. Very helpful. There you have the text. Does anybody of you need a text? Okay. So the studies noticed that there is an appearing difference in national regulation. Some countries had protection of trade secret. The others had not any regulation on that. And right from the start, there was protest against the whole plan by NGOs. We'll speak about it, for instance, the question of whistleblowing, and by the trade unions, because trade secrets, of course, have to do with employees and their rights to go, for instance, to a trade union. So they discuss that. And then we have a proposal, we have a common approach, we have a preliminary draft. Yeah? I will talk about whistleblowing in extenso. Yeah. So, and then we had on the 14th of April 2016 this decision, yes, yes, yes. If you have a term like trilogue, that means when a draft of a directive is made, a discussion starts between European Parliament and European Council and European Commission. There are three parts of a broad discussion on the draft. They are fighting against each other, finding a good text. Sometimes it takes years to have this discussion. So, you see, every European state, I think even Cyprus, who was the last, has implemented that directive. So all have the same standard, almost the same, although in implementing a directive, you have a chance to apply in national law gaps or other ways of interpreting. So there's kind of freedom for national legislature to implement a directive. If you want to see how different the national member states have implemented the directive, you find an overview of the implementation in two websites I found. So the purpose of the directive is harmonize the existing national laws on the protection of trade secrets. And you see the term misappropriation, and if you remember 5 minutes back, and the strange law professor talking to you is mentioned, misappropriation was a term used in the US code. So sometimes the codes are used in the old way, like the European Act, like the US Act. So the problem still remains. We'll talk about it in detail. What is trade secret from a legal perspective? Why do we need trade secrets from a legal point? Is it a kind of domiciliary right? That was the old view in Germany when you had the pass. Or is it a kind of little intellectual property right? Or is it an extension of contract law, for instance, in labor contracts? It's still unclear today, and nobody knows why we have this high level of protection. The directive sees the protection as a supplement or alternative to intellectual property rights. But they also say, I use here now certain remarks in the text itself, in the preamble. So in the preamble, there's a recital 2 saying is a complement or an alternative. In 3, it says it's the most commonly used form of protection of intellectual property. And then it says in 16, we don't want to create any exclusive right on know-how. There you see the problem. They said it's a kind of small minimum intellectual property right, but we don't want to have exclusive rights, so it's in between. That's the reason why we are talking about trade secret today. So, for Germans, Austrian people, and even for Swiss people, although they don't have a trade secret protection, it's also unclear what is the relationship between unfair competition law and trade secret. We had unfair competition law in our UWG, that's the old Gesetz against unfair competition, but that has been changed, has been cancelled. So it is still unclear how we define the borderline between unfair competition and trade secret. Another term missing in the directive, conflict of laws. You know, if you, for instance, say, what we're talking about in in trade secret law is criminal law. Trade secret is part of criminal law. You have the territoriality principle. That means the law of the state is deciding a matter where the territory of violation is, the mother country of violation. If you say trade secret is a term which has to do with intellectual property rights, then you have a principle called place of use. Where is a trade secret being used at the end? No? That's another rule and leads to very important differences in applying law. Or if you say it's unfair competition law, then you have the principle of final market protection. So you have to ask, in which market is trade secret being used? Where is the trade secret directed to? So these are different principles, and nobody is aware which is the correct principle. If you're writing doctoral thesis here at the institute, one day you will write all your doctoral thesis at this institute, and then this is an important topic for writing your famous book. Let us go to the definition part. So, first question, what is a trade secret? Means information which meets all the following requirements. It is secret in the sense that it is not generally known. It has value because it is secret. It has been subject to reasonable steps under the circumstances to keep it a secret. If you remember, almost 30 minutes ago, I just had a similar definition in the US Act. So here you have three conditions: secret, commercial value, and reasonable steps to keep it secret. Let us talk about what is what. So, first thing is, it is not generally known or accessible. I have just written down that is old 19th century. Please keep it secret. This is secret, very secret, very secret. In the area of hacking, in the area of big data, you can find out data which are, of course, unknown to most people, but the Russian hackers, they know, of course, know it. So, is that secret?
It's not even the big data or hacking as well. Because there's so much data in the world now, it's hard to keep. Sometimes data, it's there, and sometimes it goes in the wrong hands sometimes. So it's not even by hacking, it might go to you sometimes. It might just land in that. And how would you...
I'm sorry.
The problem.
I'm sorry. As a part of the audience, we didn't hear what the person said.
Next topic. It says generally known. What does generally mean? What is the target principle? So if stupid people in Steinfurt, where I'm coming from, don't know an information, don't understand an information, is it generally known or unknown? Nobody knows what is the circle we are talking about. Then second topic, commercial value because it is secret. That's new. We don't have it in Germany and France and Italy to say you need to prove which data, which information has which commercial value. So you have to check all your accounting systems and find a certain commercial value defined for a specific secret information. That leads to another problem we cannot solve. Because if you have to find it in the accounts, the account is a public data. An account sheet is published in the Bundesanzeiger. Then a hacker might say, the best thing to get secret information is simply to use the official journal and checking all the accounting data. That's really a big problem. Nevertheless, you have to make a paper trail. Paper trail means you have to, if the judge is asking, is that information valuable, you have to find the paper proof to demonstrate which value has a secret. I had a very nice student called Long Bui. He's very known, I think, in Münster. Very fresh guy, always talking on LinkedIn and talking to people. He has just published his doctoral thesis on the commercial value of secrets. How can you define the value of a secret? That's 400 pages dissertation. So a very good hero, and for you to say, I want to make a dissertation published by ITM. And the third element is the most important. The definition said it has been subject to reasonable steps to keep it secret. That's totally new, especially in Germany. We have recommended in the past to do reasonable steps, but only as a recommendation. Now it's mandatory. You have to prove that you have made reasonable steps to keep a secret. So, how do we do it? Let us use one example. That's called catch-all. Catch-all is simply a clause in a contract saying every information of which we are talking about is secret. Even the contract is secret. Everything is secret. I declare everything in our business relationship to be secret. Is that valid? No, said the court in Düsseldorf. They said such catch-all clauses are totally invalid. We have to specify what is the secret in detail. That leads to another problem. The problem is, again, you have to talk about your key secrets. So the best thing to do is to be in contractual discussion with the other part on secret. You are talking, the secret is that, pure 5, 6. And the other part is saying, wow, now I know what is the secret, what is mostly protected by secrets. So you see that it's always dangerous to draft a good contract and to get secrets protected, although you are talking about your secrets to somebody who's then saying, wow, I want to get any information. So what you need to do in reasonable steps is a thing I call 2G. First, you have to have LOE. So I'll write it down. So for 2G, means first you have to draft an LOE COR or NDA. Does anybody of you know what is an LOE? LOI. Nah. It's a letter of intent. So when you start a corporation, you have to have a letter of intent for the corporation protecting your secrets, which we are talking about, to your partner. NDA is a non-disclosure agreement, and COA is a confidentiality agreement. It's all the same. You need to draft an agreement for protecting your trade secret. And the second thing It's called nicely Tom. It's not my first name. It has to do with technical and organizational measures. That means you have to say, how do you want your secrets to be protected from a technical point? That's very important for data security. So never talk to somebody who simply uses his laptop on Mallorca or uses USB sticks in his pocket. That's not a good guy. So you need to have technical measures, and plus means, according to German, Austrian courts, depending on the circumstances, you need more. Perhaps you are a big company like Daimler, and you don't want your cars, new cars, to be seen by the competitors. Then you need 1, 2, and third, a blanket put on the new cars, and a control system, who is entering the premises, and so on. That's very important. So I've used that slide to tell you ideas about existing trade secrets. Of course, the Coca-Cola recipe is one, but advertisement concepts as well. Take, for instance, decision of the Supreme Court in Germany. The DHL has the vision of sending a post package to the moon. So they made an advertisement campaign. We will send your package to the moon, and they send it to the, oh, I miss the English word, to, they send it to the sky, at least to the sky. And that was a brilliant idea, but one competitor of the DHL said, wow, that's a great idea. We will be first in the sky. And they copied the whole idea because they had the files. And they said, we want to be send our package first to the moon. Customer list is, of course, very important as trade secret. LuxLeaks, that is financial information on who is buying Aktien in Barbados and the Cayman Island. Dieselgate was as well one. So somebody discovered what Volkswagen did with his cars. I have just said most trade secret litigation is brought out by companies against their current or former employees. There's one problem which is always has never been solved. What is happening with knowledge in the brain? Knowledge in, I was a judge in the Court of Appeal in Düsseldorf, and one day we had a case where a former employee left the company and said, I hate this old company, and he doesn't steal any document, nothing. But he was a famous engineer and constructor for factories in the company. He went to a new company, and He said, in the moment where I start work for the new company, I felt my brains getting to work, everything was fine. And I remembered all these construction plans for these old factories, and I rebuilt modern factories. The old guy, the old employer said, "You shit guy, you damn old fucking son of a bitch. You're stealing my information simply by having it in your brain." And that's a total violation. We said it's not a violation of trade secret law because you haven't copied a file, but it's unfair competition to use your knowledge in your brain. The Federal Supreme Court killed us and said the Court of Appeal is totally wrong because the knowledge in the brain belongs to the employee. It's his brain. It cannot be protected by somebody else. If he remembers all his information, that's free. Does this sentence is still valid under this directive? Nobody knows. So again, if you want to write your dissertation, your master's thesis, you're always welcome to write it. Okay. So I will now go to Article 4. Because in Article 4 you have the famous prohibition, the general prohibition. The acquisition of trade secrets shall be considered lawful when the trade secret is applied as 3.4. Member states shall ensure that trade secret holders are entitled to apply for the remedies to prevent the unlawful acquisition, use, or disclosure. And then it's more specified in Article 4, subsection 2. The acquisition is unlawful when carried out by unauthorized access, and then B is horrible. If you look at B, any other conduct which under the circumstances is considered contrary to honest commercial practices. What does honest commercial practices mean? Nobody knows. It's not explained. It's a very broad. So the concrete provision is in subsection 2A. So I've just written is unjustified, stupid sense isn't made not very clear. Then we have in Article 4.3, remember Article 4.2, acquisition, the word is important. Then we in 4.3, use or disclosure shall be considered unlawful when made by a person having acquired the secret unlawfully, is in breach of a confidentiality agreement or in breach of a contractual duty to limit the use. That is what is prohibited. The terms are very complicated in detail to understand. But what is fascinating is that this principle of prohibiting of the acquisition and use and disclosure is extended in subsection 4. This use acts shall also be considered unlawful whenever a person has know or ought to have known. That's, you remember the US Act. It has the same principle. That's called the indirect knowledge. So it's not a prohibition only for the employee, but also for the third person who is using the knowledge for producing any object. So it's not only a protection against a former employee of Uber, but also against the same person working for Google and the same for Google itself. That's called an indirect violation. And that makes living with this directive very, very harsh. So let us skip and go to 3. Everything fine? You understand everything I said? Okay. Then you have Article 4 saying a general provision, and then we have limitations. There's Article 3 and 5. The structure is not very clear. Draft 4, a general provision, then exemptions in 3 and 5. Let us talk about first in 3. The acquisition of trade secrets should be considered lawful. A, independent discovery or creation. B, observation, study, assembly of a product that has been made available to the public or that is lawfully in the possession. C, exercise of the right of workers representative. You can feel that the trade union heavily protested against every restriction in getting contact to a trade union. Therefore, they have said and see every worker has a right to go to a trade union or to a workers' representative. So, first, what I explained to you last week is, of course, a harsh criticism, even in the terms of the directive. When I said last week, information wants to be free, and intellectual property rights are an exception, I said, then limitations are never limitations, but they only give the freedom of information back to the person who wants to talk. So limitations of an exclusive right are never exceptions, because exceptions are interpreted narrowly. That's very dangerous. So exceptions are in fact exemptions. So that was a mistake made in the directive. So first exemption, independent direct discovery or creation. There's a typical example in copyright law. Perhaps you remember the Grand Prix Eurovision, the chanson. Every time somebody is winning the Grand Prix, another person is complaining and says, I have composed that song 2 years earlier. So you've stolen my song. I want to complain and want to get money. Then the other said, I haven't seen you at all. You're a demo fucking son of a bitch. I have composed that song independently of you. I didn't know you. So there's a typical problem called in Germany Doppelschöpfung. What is happening if two composers by chance compose the same song or similar song? And that is possible, that is accepted in copyright law, and here you have the same. If you have independent creation, that is possible as an exception. That phenomenon can also be found in patent law. Then Article 3(1)(b), observation, testing of a product that has been made available to the public and or that is lawfully in the possession. That is called reverse engineering. That's new. We haven't had it before. Reverse engineering is free. Perhaps coming from Britain, you know the company Dyson, very famous and very powerful, making beautiful vacuum cleaners. But Dyson is in fact stealing ideas from Miele. Miele is, has a big department for innovation and creating vacuum cleaners in a new way, selling the vacuum cleaners. And what Dyson does, sorry to say, is not a fight between Germany and Great Britain. The Dyson people are buying a vacuum cleaner, a new vacuum cleaner from Miele, and they use that machine in their laboratory to say, what is new, what has been invented by Miele? And then they using these ideas for the Dyson vacuum cleaners. I know it from several cases from Düsseldorf. That was totally prohibited in Europe, of course, but now it's allowed because that is reverse engineering. And there's a big danger in the area of AI, because in the area of AI, for instance, they invented Watson. Watson is a software, AI software, for checking all the information of a company and asking what is happening at that company. You can find out everything which is secret in a certain competitor simply by using AI from IBM. So is that reverse engineering? Yes. And that is allowed. That is an object, information, which you can use for your AI tool to check all the internal aspects in a company. The only chance to rescue Miele is to see is meant who is free from any legally valid duty to limit the acquisition. You can say, I will prohibit reverse engineering contractually. But there is one problem. If you see the sentence here, you have a one or that has been made available or that is lawfully in the possession. Can you contractually restrict only that is lawfully in the possession? Or does it also apply to the first mentioning that has been made available to the public? Totally unclear, because nobody knows, understands the sentence. Clear? So there are, of course, there are always three solutions in German legal structure. One is yes, one is no, and one is yo. So the first people say in literature, the legal valid duty applies to every case mentioned in 3.1b. So you can restrict every kind of reverse engineer. The others say, no, no, no. That only applies to these lawfully in the possession. It's your choice. You are deciding what you want to do. The problem is, furthermore, restricts for Dyson, because Dyson buys a vacuum cleaner on the free market, simply going in the shop and buys a vacuum cleaner of meter. They don't have a contract which is restricting reverse engineering. They don't have a contract with meter. So the problem is still one of the big problems of this directive. So what else? That's the term reverse engineering, testing. And there you see 3.1c, exercise of the rights of workers. That is, of course, exempted. And then we have the barriers of Article 5. I have a clear look. The one is called exception, Article 3, and the other is called expressly exception. So what is the relationship between Article 3? Is Article 3 exception or not? Because Article 5 has it so strictly in the title. So Article 5 says, exemption for exercising the freedom of information. There you see the balance again, by the way. Freedom of information as a general principle, then trade secret as an exception, really as an exception, and then the so-called exception of Article 5, giving back the freedom to the freedom of information. To be concrete, that means freedom of press. So the press can simply say what they want. Nobody can use trade secrets to restrict the freedom of the press. Of course, we still have a problem. What is press? What is freedom of information? Is a blogger, for instance, is an influencer blogging on YouTube? Can you be protected by this freedom of information? So, and then we have your problem of whistleblowing. It's mentioned in B, for revealing misconduct, wrongdoing, or illegal activity, provided that the respondent acted for the purpose of protecting the general public interest. This is very difficult to understand. Let me say first, your question, what is a case where trade secret conflict with whistleblowing? If you are working for BASF, a big company, a chemical company in Germany, and you're discovering as an engineer that BASF is producing glyphosate. That's a very dangerous chemical product causing cancer. And you say, I cannot live, I cannot sleep in the night when I see that my company is producing that product. I want to go to press and inform everybody about the situation. There's a conflict between trade secret on one end and whistleblowing. So I hope I have made myself clear. So that was, of course, a heavy fight with NGOs who said that has to be integrated in the broad sense, because if you interpret that section too narrowly, it's very bad. And again, you're coming to the term on the top, exception. Exception means you have to interpret it narrowly. That's a wrong decision to mention that as exception. Take, for instance, one word. For the purpose of protecting the general public interest. What is happening with the whistleblower who is discovering tax data to the tax authority, not for general public interest, but for money? So he's selling a CD, a DVD with the data of all these very bad people in the cum-ex business. So he's not working for the purpose of protecting the general public interest. So you have to interpret it in a broad sense if you want so. Of course, the enemy is saying that has to be interpreted very narrowly, exception, and that's all. What is meant with misconduct, wrongdoing, or illegal activity? Think of a whistleblower who said, my farmer, so my employer is working as a farmer, and he is mistreating his cows, not in a way violating acts, but is violating the general principles of taking care for cows. Is that illegal? No, of course not. Is it a wrongdoing or a misconduct? So the question is, how far can we extend this principle? That's all mentioned on the slides if you see it at home. I propose to use the Whistleblowing Act from Canada because there some principle are explained. So, and I mentioned, of course, another directive which you should be aware of. It's totally unclear how this second directive works together with that directive. We have a European Whistleblowing Directive, which is coming from 2019, and it's clear said that big companies have to provide a whistleblowing scheme, a whistleblowing system where everybody can use and claim, I want to be a whistleblower in the case. But that's the only decision made in that directive. It doesn't say he is exempt from liability. So you can go to a whistleblowing officer in a company, you can complain, but the consequences are not clear. For instance, with trade secret. Can a company sue against a whistleblower saying you have violated my trade secret? Very unclear. So, and the last topic, civil law enforcement. How can you inform, which rights do you have against a violator of trade secret? That is mentioned in Article 6. and the member states shall provide for the measures, procedures, and remedies necessary in general. There's a new idea in Article 7, because it said the measures have to be checked according to the standard of reasonableness, because in patent law, in copyright law, we integrated the same measures. The measures should be appropriate, avoid the creation of barriers, providing for safeguards against abuse. So you can make a lawsuit against somebody trying to enforce his trade secret. That's called, by the way, anti-SLAPP. There's a new directive even made for that. You have the right to say, you are fighting against me, for instance, as a whistleblower, and that is too harsh. You are fighting for high damages, which are abusive, and then you can say, stop that action. So, nevertheless, we have a whole bouquet of claims. You have damages mentioned in damages mentioned in 14 as well. So you can say, I want to get damages. Damages are usually calculated in 3 ways. You get the lost profits, you get the profits used by the violator, and you have a typical license fee as part of damages. Then you have in Article 7 the right to recall of infringing products, the right to claim removal and destruction. So, of course, for all the rights which you get, which are really astonishing, that's the reason why in Osnabrück, a colleague of mine is fighting for the theory that trade secret protection gives a real intellectual property right. She says, if you have a look at all these sanctions, of all these damages, it's almost the same as violating copyright law, as violating trademark law, is a real intellectual property right. And I'm heavily fighting against her in Osnabrück. You see always a problem of Osnabrück fighting against Münster, because I say it doesn't matter which rights you get. It's only unfair competition law. It's not saying intellectual property right. By the way, we need that right, of course, not because only trade secret is important from an economic principle, but trade secret will follow us in discussion with AI regulation, with the Data Act. There you see some references of the Commission saying trade secret is a limitation of AI Act, of data rights. So it's very important for future elections. So that is all for damages. And that is all for this directive. Next week, we are talking about a real intellectual property right. So we have only made trade secret as a minor right, whatever it is. We are talking about copyright. And copyright is I have written an article 20 years ago. Copyright is a Magna Carta of information. That is really the master right of information. Therefore, we need 3 lectures to get a view on copyright law. Next week, I'm speaking about the history and the general structure of copyright law throughout the world. I'm not speaking about Germany. Then I need another time to explain to you 2 different models in copyright law invented by the European Commission. That means software protection and database protection, because that's is in the information society a very important feature. Then the next lecture, somebody from Queen Mary College in London will come and will talk to you about the acquis communautaire. That's a very nice word. On what has been decided by the European Court of Justice in a general copyright matter. And then we will apply in the 3rd lecture all this knowledge which we got on software protection, database protection, and acquis communautaire in AI protection. We're we need to have 1 hour for checking what is happening if a company is using thousands, millions of data within ChatGPT. Are they violating copyright law? Very important topic just discussed by the District Court of Hamburg 2 weeks ago. That is all what we want to do. I think within the 2 weeks, we have a Q&A session as well as an additional session. That means you have the chance to ask any question during 1 hour which you want, but it will be done by Zoom. I expect you all to be here, because you are the guarantee that the Münster people are listening in person, not by Zoom. And that is foreseen even in the regulation of our faculty. Münster students, it doesn't matter where you come from, are obliged to sit here. I hope you had a good time and had understand what I want to say in very bad Germanic words. Everything fine? Okay. See you then.
Thank you so much.
Next Tuesday.
Thank you, Professor.
Thank you.
Thank you. Have a nice day.
Bye.
Vielen Dank. Schönen Tag noch.
Thank you.
Vielleicht nur eine Anmerkung, one remark from my side, if not too late. Hi. If the audience in the present, who are present and not online, are speaking, the questions are not really